The Johnson v. Dunn case, this sanctions opinion is 51 pages long, and the judge did that for a reason, to set a precedence and a message. And this judge, to say it in perfect legal terms, was pissed. Butler Snow LLP, they have 400 plus lawyers, 20 offices between the US and London, not a small firm, not a boutique, plenty of resources. The cast of this mistake is actually pretty big. You have a partner and senior practice group leader who actually used the ChatGPT tool. He queried it for supporting case law on 2 narrow propositions. He got the citations, he put them into his motions, he sent the draft to the junior attorney for filing. Didn't verify. Neither the partner nor the associate verified. They also had an of counsel at the firm who was a senior practitioner. He drafted initial versions of both motions as well, submitted them to the partner I spoke about earlier, and he did use a GPT tool to edit, incorporate changes, grammar. He did not verify a single citation that either the associate or the other partner had added, okay? And the list goes on. There's another partner and practice group leader. So how many are we at now? There's 3 lawyers so far. He was a principal responsible attorney for all of the matters in this case. He spent 15 minutes scanning the motion to compel that was ultimately filed on Sunday night, focused on the facts and the bolded headings, and did not review the legal citations. The playbook doesn't end there. You have another associate who was copied on emails, circulating drafts. He didn't revise, he didn't review either motion. He was released without sanction. He was just CC'd. There was another attorney, erroneously included in the signature block by one of the partners, had no knowledge of the motions. This is another problem. And it wasn't until the show cause hearing was set that the attorney was like, why am I being dragged to a show cause hearing? And somebody said, well, because your name is on the bottom of the signature pleading. He's like, I didn't even know I was on this case. The firm, in the irony of irony, had sent a firm-wide warning email in June 2023 saying that AI output can, quote, appear perfectly researched and logical while in fact wholly inaccurate. Imagine the egg on their face when they hold to the judge, yeah, Your Honor, we have this beautiful policy that's worth nothing. Butler Snow commissioned a 28 attorney team at Morgan Lewis to independently review every citation across 330 filings in 40 dockets. Why? Because they were forced to do it. The firm absorbed all costs and charged nothing to the state of Alabama. The state was their client, a sophisticated client. 5 fabricated citations. They doubled down on it. At no point did anyone stop and say, should we check these cases? It seems almost mind-boggling, but it happened. Judge Manasco in this court said, quote, time is telling us quickly and loudly that those sanctions are insufficient deterrents. And quote, the reality that this lapse in judgment presented in the most spectacularly unforced fashion underscores the need for more than a fine and reprimand. They had to notify the clerk with the listing of jurisdictions in which they are licensed to practice law within 24 hours of the order. Why do you think that is? They have to serve a copy of the order on the general counsel of the Alabama State Bar and any applicable licensing authorities for further proceedings. The 3 named partners disqualified from further participating in the case. Further reprimands, providing a copy of the letter to their client